आएगा सबके लिए आकाश आएगा सबके लिए उल्लास आएगा सबके लिए विश्वास आएगा सबके लिए अपने इस हिंदुस्तान पर हक हमारा भी तो है इंसाफ की इस आशिया पर हक हमारा भी तो है एक मुट्ठी आसमां पर हक हमारा भी तो है एक मुट्ठी आसमां पर हक हमारा भी तो है ये न सोचो डर हमारा कहीं सुना न जाएगा अब न्यायालय खुद चलकर चौपालों तक आएगा लाचारों को न्याय मिलेगा दुखियारों को न्याय मिलेगा कमजोरों को न्याय मिलेगा मजलूमों को न्याय मिलेगा अपने इस हिंदुस्तान पर हक हमारा भी तो है उम्मीदों के इस गुलसितां पर हक हमारा भी तो है एक मुट्ठी आसमां पर हक हमारा भी तो है एक मुट्ठी आसमां पर हक हमारा भी तो है गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा न्याय सबके लिए
Honorable Justice Sona, Honorable Justice Deshpande, Honorable Ms. Justice Mehta, Learned Advocate General State of Goa, Senior Advocate Devidas Pangam, the Learned Principal District Judge North Goa, Judge Aga, Learned Principal District Judge South Goa, Judge Sherry Paul, the President of the Goa High Court Bar Association, Senior Advocate Sukoilo Pereira, Member Secretary, Goa State Legal Services Authority, Ms. Shabnam Sheikh. Good evening, everyone. On behalf of the Goa State Legal Services Authority and the Goa High Court Bar Association, I extend a very warm welcome to all those present here. Let me make a special mention to the students and my colleagues at the bar. Well, 26th of November is a very special day. It is celebrated as a National Law Day, and that is for a very significant reason. On 26th of November 1949, the Constituent Assembly adopted the Constitution for India, and on the 26th of November 2024, it will be 75 years since the adoption. So we have organized this function in anticipation of the landmark day. It was on the 26th of November 1949 that the Constituent Assembly and the members of the Constituent Assembly adopted the Constitution. It took almost about 3 years in the making. If you really have to go by the start, it all germinated from the Cabinet Mission Plan, which was released on the 16th of May 1946. The Constituent Assembly and the formation by itself is a topic for discussion, a very fascinating topic for some other day. But the first assembly of the Constituent Assembly met on the 9th of December 1946. And you have to just, for a moment, go back and try and imagine the state of affairs at that point of time. We were grappling with financial strife. We were deeply rooted in caste discrimination, in class discrimination. We had a colonial mindset, and the politics was polarized. In such a scenario, we had given this task to the Constituent Assembly to come up with a vision for the future. And in fact, the situation was so grim and gloomy that the great Dr. Ambedkar, I'm not sure how many people know about it, but the architect of our constitution, in fact, addressed a memorandum to the cabinet mission, specifically requesting them not to have a constituent assembly. He, in fact, expressed his opinion that considering the constitution is not really a technical subject, the British should give us the constitution. This is a memorandum specifically addressed by him. And he said you could have a British jurist who could then deal with the technicalities. And to take things further, he says wherever there are communal issues that could be addressed by those roundtable conferences. So that really is indicative of the multitude of situations and problems that the country was grappling with at that point of time. But once the Constituent Assembly took the mantle on the 9th of December 1946, they worked overtime. We speak so much about Dr. Ambedkar, but I think Professor Rao needs as much recognition because he actually pieced together 12 different reports. He addressed questionnaires whereby he gave references of all the world constitutions to all the members of the provincial, central, and the Constituent Assembly members. And he invited objections, their suggestions, and then there were all these reports, which includes the report of prepared by Dr. Ambedkar with regard to the fundamental rights chapter, and he pieced it together and presented the draft constitution. So, which largely stood scrutiny in the Constituent Assembly debates. So, it was around the 9th of November that the Constituent Assembly, 9th of November 1948, that the Constituent Assembly debates started, and they concluded around in the month of October of 1949, and subsequently the Constituent Assembly adopted the constitution that we have for ourselves. So that is the significance of the day. It's a landmark day, and we have with us uh, an August gathering today and a very special keynote speaker to mark this occasion. So let me start the program by greeting the dignitaries who have graced the occasion by their presence. May I request my colleagues, I will start with Simon Kuria, to kindly greet Honorable Justice Sonak with a potted plant.
Thank you very much.
Thank you, Simon. May I request Tahira Menezes to kindly present a potted plant to Honorable Justice Deshpande. Thank you, Tahira. May I request Tanisha Mashelkar to present a potted plant to Honorable Ms. Justice Mehta. May I request Arya Parikar kindly present potted plant to the Learned Advocate General, State of Goa, Sri Devidas Pandal. Simon, I'll leave you back again. May I request Simon to kindly present a potted plant to a learned Principal District Judge, North Goa, Judge Irshad Aga. Next, I request Tahira Menezes to kindly present potted plant to learned Principal District Judge, South Goa, Shrimati Sharif Kaur. We'll keep that for the later. Um, well, we are all ready to start the main part of the function. May I request the President of the Events Committee, Senior Advocate Sudhir Usgaonkar, to kindly introduce the topic for today's lecture and the keynote speaker.
Respected judges, senior advocates, and my esteemed colleagues, including all of you. Yours truly has been appointed by the President of the Association using his executive powers, just as he has been under the American Constitution. They're called secretaries, they're not elected. So I'm not an elected member, but he nominates. So he has taken the American Constitution.
Requires consent of the Senate.
Yeah, okay. Well, friends, first I have to quickly introduce our honored keynote speaker. And normally we say the speaker doesn't need introduction. But sometimes we just say formal, but here he doesn't. He doesn't really need introduction. Justice Mahesh Sonak, for all of you, Mahesh, for many of us who have been practicing together, has been here as a judge. He's a Panjim boy, a brilliant student, astute advocate, an outstanding judge now, and with remarkable judgments to his credit. As I said, orator par excellence, because speaking the court, we addressed two judges or four judges or four ICS Justice Bobes the other day. And as a judge also, you can see some people, but when you face a crowd, you really require guts. So I have seen him from college days as an orator, studied matter, voracious reader, and I think he's been here in the past, but the subject is such that you need to hear him more and more. So we have, and we are pleased to have you, sir, amidst us today on this presentation to speak, to hear you on this subject today. Now, coming back to the subject, Constitution Day, National Law Day, as Shivan said. Many times we mock at America, saying that it's a very young country, we have a very old civilization running for 1,000 years. But as far as the Constitution is concerned, they have the oldest Constitution. Please correct me, sir. And it is a very strong Constitution. I'm not going to translate in his territory. And when our Constitutional Assembly was formed, as my colleague Shivan said, they had to study all. You know, in Britain, they don't have written here, America is written. So all they studied, and they try to take the best from everything. So this Constitution, which I just read, was implemented, came into force in 1879, and stood test of time for more than 200 years, very strong, sturdy. It was all the powers of Congress, Senate, representatives, how the powers are delegated. I'm not going to dwell into that, it's its subject. So, my friends, I have pleasure in presenting our esteemed speaker on this esteemed subject. Of course. My brother Justice Deshpande, sister Justice Mehta, President Pereira and his excellent team, Advocate General, senior advocates, members of the bar,
fellow students. I'm told that students are also here. So you are fellow students, your professors, boys and girls. Good evening and thank you so much for having me with you all. Friends, in 2009, three researchers, Alkins, Ginsberg, and Melton, conducted a study entitled The Endurance of National Constitutions. Now, based on detailed empirical studies written of constitutions since 1789, as Mr. Senior Advocate Mr. Usgaonkar told you, the US Constitution is the oldest and it entered force in 1789. So they did a study of the written constitutions in 1789. And this research reported that the average lifespan of a written constitution is between 17 and 19 years. Only a handful have lasted beyond 50 years. The lifespan varies from region to region and from generation to generation. Written constitutions in the West have an average lifespan of about 32 years and in the East of about 17 years. So, dear friends, we have every reason to be proud that our written constitution, which is the longest in the world, is batting at 75 not out. There have been some scares, but 75 not out is certainly something to be proud of. And today we have gathered to celebrate this achievement. But not just that, we have gathered here to affirm our faith in our constitution. Dr. Ambedkar, the father of our constitution, in this very month, 75 years ago, famously remarked that however good a constitution may be, it is sure to turn out to be bad because those who are called to work it happen to be a bad lot. He added, however, that a bad constitution may turn out to be good if those called to work it happen to be a good lot. Uh, I have I have deficiency in preparation, so please allow me to present today a clip of Ambedkar speaking in the Constituent Assembly. I am told that this is a picturization, this is not the original, but let us have a look for about a minute or so. No, the first one.
मैं यहाँ पर संविधान की अच्छाइयाँ गिनाने नहीं जाऊंगा क्योंकि मुझे लगता है कि संविधान कितना भी अच्छा क्यों ना हो वो अंततः बुरा साबित होगा अगर उसे इस्तेमाल में लाने वाले लोग बुरे हो।
Now the Constitution can only provide us the organs of the state, such as the legislature, the executive, and the judiciary. The Constitution can also give us a broad framework, as in the case of the American Constitution, or even make detailed provisions for governance, like we have in our Indian Constitution. The factors on which the working of those organs depend are ultimately the people. The people's resolve to see that those who are called upon to work the Constitution turn out to be a good lot, and the people's resolve to respect this Constitution. And friends, there can be no greater respect for the Constitution and the constitutional principles than obeying the Constitution by not transgressing the constitutional limits, developing and imbibing such a spirit, such a habit, so that it becomes a way of life with our people, and striving towards this is the best tribute that a grateful nation can pay to its own constitution. Now, friends, some of the factors, basically those researchers which I referred to, some of the factors contributing to the longevity of a written constitution are: first is the specificity of its provisions, second is inclusiveness, third is a balanced mechanism for its amendment, the fourth is an independent judiciary to patrol the constitution's boundaries, fifth is the willingness of the coordinate branches, that is the legislature and the executive, to accept the court's interpretation of the constitution and the court's decisions. even if those decisions appear to be counter-majoritarian or anti-majoritarian. And sixth, this he says, this they say is the most important aspect, is the people's willingness to accept the court's decisions, even if they disagree with them, even if such decisions are unpopular and are not immediately palatable. Now, friends, our constitution, according to me, fares reasonably well on specificity. It is pretty specific, and in fact, one of the criticisms was that it is too detailed. In 1951, Sir Ivor Jennings, a leading Commonwealth historian, jurist, and a very famous author, spoke on the Indian Constitution. He was invited to Madras to speak on the Indian Constitution, which was just a year old. He was very critical of our Constitution and he prophesied its doom. He commenced his address by summing up our Constitution in one cynical sentence: too long, too rigid, and too complex. And to add insult to this injury, he said that the dominance of lawyer politicians in the Constituent Assembly had contributed to the complexity of its provisions. But as Fali Nariman has pointed out, harsh words like chickens often come home to roost. In the 1960s, this Sir Ivor Jennings was commissioned to draft a new constitution for Ceylon, or Sri Lanka as we call it. Despite his scholarship, his precautions, this constitution lasted for exactly 7 years. And here, the constitution, which was damned as too long, too rigid, and too complex, is celebrating its 75th birthday. This is an achievement that we can be proud of, and I think we are all right on the aspect of specificity. The same goes for inclusivity, which is the second factor. Our constitution provides for affirmative action, protection of religious and linguistic minorities, equal treatment, which means that likes would be treated alike, and special provisions for those who need them. The aim is to provide a level playing field. Fraternity is one of the objectives spelled out in the preamble to our constitution. So all this, according to me, promotes inclusivity. Regarding balanced amending powers, our constitution has tried to reconcile the urge for change with the urge for continuity. Change without continuity can spell anarchy, and continuity without change can mean stagnation. The world around us is constantly changing, and if a fundamental law like the Constitution does not keep pace, that would not be good either for the world or the Constitution itself. Constitutions evolve with society. No generation can claim a monopoly over the Constitution or over the wisdom of those times. A written Constitution must not be so rigid that any attempt to change it would lead to its breakdown. So also, it must not be so flexible that it becomes a plaything in the hands of the politicians to be tampered with and degraded to the level of an ordinary statute liable to change with the passing fancy of those in power. These are not my words, these are words of Justice H.R. Khanna in Keshavananda Bharati. So our constitution strives to balance between rigidity and flexibility. So amending our constitution may not be too difficult, but it is not too easy either. We are all right on this parameter of balanced mechanism for amending the constitution. I believe we have a reasonably independent judiciary. At least I would like to believe that. Based on that independence, I would like to discuss the last two aspects that contribute to the longevity of a written constitution. The willingness of the coordinate branches to accept the judiciary's decisions or interpretations, and the willingness of the people to accept the court's decisions, even though those decisions may not be popular at the moment. You might legitimately ask me why I chose the American experience rather than the Indian experience. 75 years is, after all, a reasonable time to reflect upon. And this is correct, but still I offer two reasons. First, as a sitting judge, I do not know if any utterances or instances would unwittingly conflict with my functioning. And second, the cases from American experience show that they began badly. In fact, they began very badly. They had their hiccups, they had their scares, but they recovered and evolved over the last 200 years. The people evolved. The constitution also evolved correspondingly. It was a long, drawn out, and a difficult process. From this, I think we need not be overly pessimistic or focus only on our mistakes or downplay our significant achievements, including the one that we celebrate today. 75 not out is no mean achievement, but we must collectively guard our constitution against injuries and fatigue. In cricket, a batsman cannot decide who the bowler will be and how the bowler will bowl. However, the game cannot be proceeded smoothly unless the teams agree to abide by the umpire's decisions. The umpire must be independent of the two teams. The umpire's decisions may not always be correct. They may be wrong or even grossly wrong on some occasions. But if the game is to survive or live long, the decisions must be obeyed until they are lawfully altered. There may be several pitfalls in the American society. I do not advocate for a moment emulating them in all respects or even in substantial respects. But however, that does not mean that we should not accept whatever little that is commendable in their constitutional culture. And there is no reason why we should not learn from the American mistakes and try to avoid those mistakes in India. I chose the American experience because their constitution is the longest surviving constitution, as pointed out by senior advocate Mr. Sudhin Usgaonkar. It has survived for 237 years. Your learned AG also pointed out that this is the longest surviving written constitution. The British constitution is of course 1,000 years old, but they do not have a written constitution. The US constitution, the longest surviving written constitution, is also the shortest. It has just 7 articles. And for the last 237 years, it has been amended only 27 times. Our constitution, I think, has been amended
106 times. 106 times.
106 times. Allow me, therefore, to refer to the history of this constitution, to some precedents from the US Supreme Court, and more specifically, to the reaction of the executive, the legislature, and the people of the United States to the unpopular decisions of the US Supreme Court. In this study, we could perhaps find an elixir or the secret to the US Constitution's longevity. Now, the US Constitution does not contain any provision like Article 13 of our Constitution. When the Constitution entered force, when our Constitution entered force, the position of judicial review of legislation by courts was reasonably established in India. However, the position was unclear in the US. Such an issue arose, or rather was made to arise for examination in the landmark decision of Marbury versus Madison, decided by the US Supreme Court in 1803. Now, 1803 means they were just hardly about 14-15 years old. Their constitution was hardly about 14 years old. Now, a little background, if you permit me. John Adams, the first president, of course, was George Washington. He was succeeded by John Adams. Incidentally, George Washington was the first president. At that time, their constitution did not contain any bar for re-election or a bar that a president can continue, the same person can continue as a president for only 2 terms. Today, their constitution says that nobody can be a president for more than 8 years. At that time, there was no bar. But George Washington got elected once, he got elected the second time, and after 8 years, he declared that as a matter of principle, he would not contest again. And basically, his example was then later on incorporated as a constitutional amendment, much later. And that is how they have this 8-year ceiling. Now, John Adams succeeded George Washington as the president in 1797. His 4-year term was to expire on 4th of March 1801. However, as you are aware, the elections in the US are held sometime in November and December. And so they were accordingly held in November and December of 1800. The Federalists, led by Thomas Jefferson, voted John Adams out of power. Therefore, like how John Biden is today, John Adams became a lame duck president between December and March of 1801. The convention now established, I emphasize on the word now, decrees that a lame duck president should not make any significant policy decisions because he's already lost at the hustings. He's continuing in power because the term expires after 3 months. However, John Adams was very anxious to see that judicial posts are filled up by him and his political opponents, the Jeffersonians, do not get a chance to make any judicial appointments. Judicial appointments normally in the US are for a life term or for very extended terms. So what did he do? So therefore, up to the midnight of 3rd March 1801, they went on making appointments and filling up the judicial posts. John Adams made several appointments so that the Federalists had no chance to appoint any significant number of judges to the federal courts. Now, one such appointment made by John Adams was that of William Marbury. Though the warrant was signed by the President and the Secretary of the State, this warrant could not be physically delivered to William Marbury before the midnight of 3rd March 1801. Therefore, Marbury could not take charge of the appointment, as so to say. He wrote to President Thomas Jefferson, he wrote to his secretary Madison. However, both of them deliberately ignored the letters. In fact, Thomas Jefferson expressly forbade Madison from delivering those commissions or those warrants to Marbury. Now, relying upon Section 13 of the Judiciary Act of 1789, now this was an act which was passed by John Adams' presidency, and this is the act under which several judicial posts were created. There was a complete reshuffling of the judiciary, and it is under this act that a right was given to directly file a petition before the Supreme Court and seek a writ of mandamus. So Marbury, relying on this section 13, directly petitioned the Supreme Court and sought for a writ of mandamus. He said that my appointment is complete, they are only not delivering me the warrants, so issue them a writ of mandamus. Now, that time, John Marshall, who was again an appointee of John Adams itself, was the Chief Justice, one of the greatest Chief Justices of the US Supreme Court. Now, the US Supreme Court framed three issues. First was, does Marbury hold the right to the judicial appointment? The second is Marbury entitled to remedy under the US law? And the third is Marbury entitled to a writ of mandamus under Section 13 of the Judiciary Act of 1789? Now, this matter evoked considerable national interest. This is because President Jefferson was extremely critical of John Adams' midnight appointments and the haste with which all those judicial appointments were made. Thomas Jefferson was quite skeptical because he felt that John Marshall, who was very close to John Adams, has been appointed as the Chief Justice. So he felt that the decision is surely going to go against President Jefferson. So therefore, even before the case could be decided, President Jefferson declared publicly that he will disobey the writ of the Supreme Court should the Supreme Court dare to issue a writ for appointing Marbury as a judge. Now, the situation for the Supreme Court was also very piquant. If they were to issue a writ directing President Thomas Jefferson and his secretary Madison to deliver the warrant, in all probabilities, as was already declared by the President, this writ would be disobeyed. This would clearly undermine the position of the Supreme Court. I mean, you issue a writ, it is not being obeyed by the executive. What does that make of the Supreme Court? On the other hand, dismissing Marbury's petition would also be seen as a weakness, and that would also undermine the prestige of the US Supreme Court, and would also cast very serious doubts on the independence and fearlessness of the judiciary. Now, Chief Justice Marshall ultimately resolved this matter in this way. Speaking for a unanimous Supreme Court, he answered the first two issues in favor of Marbury. He said that his appointment was perfectly valid. He also said that under the US laws, he had a remedy. Now, on the third issue, on whether the US Supreme Court could issue a writ of mandamus under Section 13 of the Judiciary Act of 1789, Chief Justice Marshall ruled that this was impossible because he said that this Section 13 conflicted with Article 3 of the Constitution. He argued that under Article 3 of the Constitution, the Supreme Court has only been given appellate jurisdiction. Original jurisdiction is given only in some 2-3 cases concerning disputes between two states or where ambassadors were involved. But in all other matters, Article 3 of the Constitution said that the US Supreme Court will have only appellate jurisdiction. So Chief Justice John Marshall said that here we have a fundamental law, a constitution, which is given by we the people, and in a democracy it is we the people who are the sovereign. So a superior document like the constitution, which gives only appellate powers to the Supreme Court, and on the other hand we have a Judiciary Act of 1789, which is passed by the legislature or the Congress as they call it, and that says Supreme Court will have original jurisdiction to issue a writ of mandamus. So this is clearly a case of conflict between ordinary law and constitutional law. And then he asked a question that in such a situation, what will prevail? And he answered it by saying that obviously the constitution will prevail and the ordinary law which conflicts with the constitution will be ultra vires, which will be or it will be unconstitutional. On this ground, he refused to issue a writ of mandamus. But friends, kindly see the impact of this judgment. The Supreme Court had no provision for judicial review of legislation. The Supreme Court did not the Constitution did not say that the court would be the authority to strike down the legislation made by a competent legislature. So this last point was so significant that with this point it was established. First thing what was established was they established 3 crucial principles. Mr. Marbury lost, but that's besides the point. But the Supreme Court established 3 crucial constitutional principles. First, that the judicial branch is an equal partner with the executive and the legislative branches within a developing system of government. Second, that a constitution is a superior and paramount law. And third, any law made by the Congress which conflicts with the constitution, such a law would be unconstitutional and void. And finally, the Supreme Court held, John Marshall said, that it is within the province of a court to interpret the constitution and to decide whether there is any conflict with ordinary law and constitutional law. Now, so many things were achieved by this judgment. One thing is the Supreme Court turned out to be a very, very powerful, independent and a courageous institution. At the same time, Thomas Jefferson had no occasion to disobey the writ because that petition was ultimately dismissed. No writ was at all issued. And third thing is, the power of judicial review came to be established in this court. But friends, please imagine that this was a situation where the court and the executive came to almost an head-on collision. If you permit me, can we play that clip? I hope it's okay if we play a clip for about 2 or 3 minutes. The second one, yes.
Some scholars have called it the most important case in the history of the Supreme Court. What started out as a minor matter about federal jobs turned into a legal decision that resonates to this day. You want legal drama? You got it. This is the story of Marbury versus Madison. In 1800, Thomas Jefferson defeated John Adams in the presidential election. Just before he left office, Adams appointed a bunch of judges from his Federalist Party to the District of Columbia courts. These appointments were approved by the Senate and signed by the president. Great. But there was a holdup. The last step before these judges could take office was a commission, a formal piece of paper that said essentially, this is their job and these guys are good to go. These commissions hadn't been delivered yet, which meant the judges couldn't start their jobs yet. And when President Jefferson took office in March of 1801, he said, not so fast on those commissions. We had a Secretary of State, James Madison, keep them from legal liberty. One of those prospective judges was named William Marbury, a Federalist Party member from Maryland. Marbury said, "No fair, I want my judge job," and he brought the case to the Supreme Court. Marbury wanted the court to issue a writ of mandamus. That's legalese for a court order. Marbury wanted the court to order Madison to show why he couldn't get his commission. In 1803, Supreme Court Chief Justice John Marshall himself, a Federalist appointed by John Adams, ruled on the case of Marbury versus Madison. He saw this as an opportunity to establish some important legal precedents, decisions that extended way beyond whether or not Marbury got his job. First, Marshall ruled that Marbury had the right to receive his commission. So that means I get my judge job, right? Relax, Marbury. Marshall also ruled that Marbury had a right to remedy, to have his wrong right. Okay, so I get my job. Yeah, that's it. Relax, Marbury. Chill out, buddy. There was a third part to Marshall's decision, and this is what made Marbury versus Madison so important. Marshall ruled that the Supreme Court didn't have the power to make Madison hand over Marbury's commission. So wait, what? In making his ruling, Justice Marshall had the court rule by itself. Marshall brought up the Judiciary Act of 1789. This was a law that gave the Supreme Court the power to rule in cases just like this. But Marshall ruled that Section 13 of this law violated the Constitution because it gave the court powers the Constitution said it shouldn't have. Long story short, it wasn't the Supreme Court's place to rule in a decision like this. In striking down the Judiciary Act of 1789, Marshall also struck a blow against the authority of Congress. The Constitution, as Marshall put it, was the supreme law of the land. Whenever Congress and the Constitution were in conflict, the Supreme Court returned the Constitution. This is called judicial review, and it's been an important function of the Supreme Court ever since. In relinquishing the power that was granted in 1789, the Supreme Court defined its emerging role for the young nation. The court staked out its claim as a branch of government equal to and independent of Congress and the executive branch. All that from a case about someone's paperwork not getting voted.
So friends, just as we had our Constituent Assembly and which functioned for almost 3 years, similarly, there's a very interesting history insofar as the adoption of the US Constitution is concerned. This may really not be the time, but the best discussions one finds in what is known as the Federalist Papers. And in that, the founding fathers, basically Alexander Hamilton, he argued about what should be the power structure in this new country which was being formed. Now they felt that if the final authority to interpret the Constitution was given to the President, who is the head of the executive, then the President would become too powerful and in all probabilities he would turn dictatorial. They believed that power corrupts and absolute power corrupts absolutely. Now if the powers were to be vested in the legislature, then in theory, a brute majority in the legislature would do away with all the fundamental rights or even the basic human rights. Minorities would be unsafe, dissent or unpopular opinions would be banned, laws that may be popular but still unconstitutional would have absolute immunity. Now this would severely undermine the Constitution. Therefore, the founding fathers felt that the power to judge or interpret the Constitution should be vested in the judiciary, which should be independent of the executive and the legislature. A neutral umpire should decide whether the other two powerful governance organs were transgressing the constitutional boundaries. Now, what they reasoned? They reasoned that the judiciary has neither the purse nor the sword. Consequently, it is the weakest branch in the three departments of power. There was minimal chance that this weakest organ would itself transgress the constitutional boundaries. That is how they perceived it. Now, Hamilton reasoned that the nature of judicial power, the manner in which it is exercised, the comparative weakness of the judges, their inability to support any usurpation by force, reduced the supposed danger of judicial encroachments against the Constitution. In fact, he said that that would be a phantom. He argued that if the Constitution is to survive, an independent judiciary, which is the weakest of the three departments of the power, is a must. He argued that the judges must be appointed for a lengthy terms, if not a life term. He said that they should be guaranteed emoluments. There should be a constitutional guarantee for their emoluments. Only then they would be able to interpret the constitution faithfully and even make decisions that may be most unpopular at the moment. He also accepted that the judges may sometimes abuse their powers. However, he felt that safeguards against such abuse can be found in the transparency of the judicial process, which allows the public to assess the merits of a judicial decision and also the judge's desire to maintain a robust judicial reputation. Still, for the constitution to survive, the executive, the legislature, and most importantly, we the people must be willing to obey judicial decisions, even though such decisions for the moment may not be popular or even palatable. Without obedience, there would be no judiciary worth the name. Without an independent judiciary to patrol the constitution's boundaries, the constitution would be unprotected and vulnerable. Such a constitution would then be reduced to a paper constitution. Then might would always be right. Might can be physical or even ideological. The core ideals or the fundamental rights would then never be safe. Today, Justice Breyer of the Supreme Court, he has pointed out, and he has written some three books, wonderful books. He says that everything may be bad in the US, but they have acquired a habit, they have acquired a constitutional culture where the decisions of the US Supreme Court are accepted and obeyed, even though the people may disagree with these decisions. They may severely criticize these decisions, but to a great extent, they would obey them. They would not say that we are not going to obey these decisions at all. But friends, this was not always so. What we are seeing today is something that has evolved over the last 200 years. Now let us discuss some cases. The first case I would like to discuss is of that of the Cherokee Nation versus Georgia and Worcester versus Georgia. This painfully reminds us how the US Supreme Court decisions were most shabbily treated by the executive, the legislature, and in fact most of the people way back in the 1830s when the constitution was barely 43 years old. Now Cherokees, we call them Red Indians, or in America also they are called as Red Indians. They are the Native Americans. I always wondered why they were called as Indians or Red Indians. And then the answer to that was that Christopher Columbus had set out to discover India, but he had taken the wrong turn and he reached Americas. So the people whom he encountered first there, he said these are Indians, and then the name stuck. Now, the Georgians, the state of Georgia, where these lands were, they wanted these Indian lands badly, and the Cherokee Indians resisted all such encroachments with whatever might that they could muster. In 1819, a treaty was signed by the US government with the Cherokee Nation, giving them these lands, giving them some kind of independence to deal with these lands. The Cherokees were also allowed to have their own legal system, their own courts. Some kind of an autonomy was given to them by a constitutional treaty. But after some days in 1830s, gold was discovered on these Cherokee lands. Now, once gold was discovered, the white people in Georgia and in the rest part of America, they said that somehow or the other we want these lands. The governor of that state passed a law by which he confiscated all these lands. The president also gave an assent, President Jackson. Earlier presidents were reluctant, but President Andrew Jackson gave the approval to the Removal of Indians Act, by which all these Native Americans or Native Indians as they would be called were directed to move westwards almost 1,000 kilometers away from their own lands. Now the Cherokee Indians, and there was a kind of a war, but then their spears and horses and swords were no match to the guns and cannons which the white people had. The Cherokee Indians, completely helpless, approached the US Supreme Court. They relied on the treaty, which was given a constitutional status. And they argued that the Georgian laws, though approved by the president, were unconstitutional. The Supreme Court, by majority, accepted their argument and struck down the Georgian laws, ordered the restoration of the Cherokee lands, and forbade Georgia from deporting the Cherokees westwards. Again, this was a brave decision by Chief Justice Marshall, the same Chief Justice who decided Marbury versus Madison. Now, the question was who was to enforce the Supreme Court's order? The state of Georgia openly defied the Supreme Court order. They, in fact, passed a law forbidding the obedience of the Supreme Court order. When the matter reached President Andrew Jackson, he famously remarked, "Well, John Marshall has made his decision, now let him go and enforce it." Chief Justice John Marshall wrote to an eminent American jurist, Joseph Story, a very, very great jurist. He wrote these words. He says that I yield slowly and reluctantly to the conviction that our constitution cannot last. And as I said, this was in 1830s, and their constitution was barely 43 years old. President Andrew Jackson did nothing to implement the Supreme Court judgment, as a result of which thousands of Cherokees were forced to march westwards in very harsh conditions. About there is a controversy what the figure should be, but they say that between 3,000 to 10,000 Cherokees, mostly women and children, died on that route. Even the routes were demarcated for them. They were not allowed to go through the shortest route. And this entire trail is today called as the Trail of Tears. And can we devote about 2 minutes to watch it? Yes, this is the Cherokee lands.
For thousands of years, these mountains were home to the Cherokee. But they were just a small piece of their vast nation, which covered 40,000 square miles here in the Appalachian Mountains. In 1819, as more and more Americans started encroaching on Indian land, the U.S. government signed a treaty that guaranteed that Cherokee land would be off limits to white settlers forever. It clearly stated all white people who have intruded or may hereafter intrude in the lands reserved for the Cherokees shall be removed by the United States. Confident that the U.S. government now recognized its sovereignty over its own lands, the Cherokee Nation proceeded to build itself a new capital in 1825, here in what's known as New Echota, Georgia. It had its own courthouse, council house, and post office, and even space for the first Indian language newspaper office in the nation. In 1829, Andrew Jackson was elected U.S. President. He believed that Native Americans were savages and had no rights to their land, and began proceedings to remove the Cherokee from the southern states to clear the way for white settlement. The next year, he signed the 1830 Indian Removal Act, which set in motion one of the most brutal actions ever taken by the U.S. government. Thousands of Native Americans were pulled from their homes in Georgia and other states across the South. Many were shackled in chains and forced to walk at gunpoint more than 1,000 miles west on a series of routes that all led to Oklahoma. Up to a third of the 15,000 Cherokee who were forced to make the journey died on the way, which is one reason that journey came to be known as the Trail of Tears. Their descendants are known today as the Eastern Band of Cherokee Indians and live here on sovereign Indian land in Cherokee, North Carolina. Today, young Cherokee here at the local high school learn the language of their forebears. A vast stretch of their tribe's former land, right next to town, is now the Great Smoky Mountains National Park, the most visited national park in the nation.
So this was in 1830s, where the Supreme Court orders were clearly defied. In 1856, the Supreme Court delivered its most infamous decision in the case of Dred versus Scott. Sorry, Dred Scott's case, not Dred versus Scott. Dred Scott's case. Now, in this case, the Supreme Court held by a majority that slaves were not human beings, but they were chattel or goods, and accordingly, they had no rights under the US Constitution, even to petition to the Supreme Court. This decision was one of the focal points that pushed America into a civil war. At that time, America was blessed with the presidency of Abraham Lincoln, who eventually steered the nation away from slavery and secession. In 1861, in fact, by the 13th Amendment to the US Constitution, Lincoln piloted the amendment to the Constitution by which slavery was abolished. But though it was abolished in 1861, the process of assimilation between blacks and whites was most painful and slow. America was riddled with apartheid and segregation. This was most prominent in the southern states. The whites even made laws by which they forced the African Americans to suffer inferior schooling, inadequate public facilities, and countless of other harms and indignities. Now, in 1896, again an infamous decision of the Supreme Court called as Plessy versus Ferguson, the US Supreme Court interpreted the equality clause under the Constitution to mean that separate facilities for black and white persons was acceptable provided those facilities were equal. And that is where comes the doctrine of separate but equal. Now, this doctrine continued for almost 58 years until a unanimous Supreme Court on 17th of May 1954, not too fast. The Supreme Court, led by Earl Warren, concluded in Brown versus Broad on education that separate but equal has no place in public education. Separate educational facilities are inherently unequal. The court unanimously held that the South's system of segregation violated the constitutional guarantee that no state shall deprive any person of equal protection of laws. Consequently, Plessy versus Ferguson was overruled. Still, the court realized that immediate assimilation will have its own practical difficulties. Therefore, it directed a gradual assimilation. It remanded the matter to the federal court and said that now you issue necessary orders so that the assimilation between blacks and whites, at least insofar as educational institutions are concerned, is gradually achieved. Now, the several southern states defied the Supreme Court's decision for almost 3 years. The legislatures prevented all efforts at assimilation, not just physically, but by enacting laws that made it an offense to obey the Supreme Court's decision and even to attempt assimilation. This is in 1950s. Federal court orders were openly disobeyed. The Supreme Court in 1957 had to assemble again and reiterate its position. Still, the Southern defiance continued. Friends, contempt of court was an option, but only an option. The court does not have the sword or the purse to enforce its own decisions. The breaking point arose at Little Rock, Arkansas in 1957-58. Little Rock is a place in Arkansas. The Brown decision had directed, the 1957 decision directed that 9 black students at Central High School, Little Rock, Arkansas, are to be compulsorily admitted. They were physically prevented, not just by the white parents and students or the school authorities, but the state's police force, under the directions of Governor Orwell Forbes, guarded the school and said that we are not going to allow a single black student to enter the school, whatever the Supreme Court may say, whatever the federal courts may say. President of America at that time was General Eisenhower, President Eisenhower. He was the supreme commander of the Allies during the World War II. He was a World War II hero. The president was responsible for ensuring that federal laws or orders of federal courts are obeyed. There was a great debate. His advisors said, we better not interfere in this matter, otherwise we will have a second civil war. But the Attorney General said that we cannot afford to keep quiet because this is just the beginning. If you concede that Supreme Court judgments or federal court judgments are going to be allowed to be violated, and this is not a country which can say that rule of law prevails. After some initial bickering, President Eisenhower sent the 101st Airborne Division, comprising the heroes of World War II, to enforce the court's decision. 101st Airborne Division. If people have watched the movie Longest Day, this was the division which parachuted into Normandy, and that was responsible for the victory in World War II. So they were all heroes. They were the ones who really gave their lives, and they ultimately marched right up to Berlin and ended the World War II. So, as a statement, he said, I am going to send 1,000 crack troops of the 101st Airborne Division into Little Rock, Arkansas, to escort these children into the school so that the Supreme Court decision is obeyed. Now, these images were flashed all around the world, and ultimately, because of this action, the Constitution survived, the rule of law triumphed. Again, I know I'm exceeding my time, but I think we should see a small clip of this. There are several on the YouTube, but these the 9 children are
That much of an option that the governor in Arkansas was refusing his authority. And if he let that happen, so many other southern governors would then have the precedent to do the same thing. And Eisenhower wasn't going to let that happen. It would be chaos. And it's not hyperbolic to say it could lead to a second civil war.
Now was the moment Eisenhower had to act.
We are a nation in which laws, not men, are supreme. Mob rule can not be allowed to override the decisions of our courts.
He decides to send in 101st Airborne to enforce the law. This was one of America's proudest, most storied military units, liberated Europe, and that was now going to play a role in defending the Constitution in Little Rock.
Here we have the President of the United States saying, I am fully prepared to use the full force of my office, of the federal government, in order to uphold and enforce the law of the land. We haven't seen these kinds of deployment of troops used since Reconstruction.
We had a real show of force, soldiers that were arrayed all around the school. We had a helicopter overhead. When we walked into class, we were surrounded by a cordon of paratroopers. They took the entire United States Army to get me into high school. And it made you feel great. You felt like, 1 week, here we had a mob of people who were trying to keep us out, and that we were now being able to go into the school with the support of the United States Army. I'm the first African American to graduate from Little Rock Central High School, May of 1958.
That was very heartening in Arkansas to suddenly have Eisenhower, the hero of World War II, on the side of young people integrating Central High.
We received the Congressional Gold Medal, the 9 of us, and the person who presented it to us was President Clinton. An Arkansan to another Arkansan.
40 years later, we know there are still more doors to be opened, doors to be opened wider, doors we have to keep from being shut again now. 40 years later, frankly, we know we're bound to come back where we started. After all the weary years and silent tears, after all the stony roads and bitter rods, the question of race
is in the end still an affair of the heart. And so we wind up with this extraordinary story of a president who was not prepared to deal with the crisis of race in America, didn't really understand it, but the crisis came to him and found him.
By sending in the 101st Airborne, Eisenhower sends a signal to those states that would try and defy the federal government that, oh no, I'm going to preserve the Union, I'm going to uphold the law, and I'm going to knock down your disorder. It just so happens that he does it in defense of civil rights, and it's this moment that helps him understand what is at stake in the struggle for the civil rights movement.
So friends, the court was determined to enforce the Brown decision, but court was not solely responsible for its enforcement. The arrival of the 101st Airborne paratroopers on President Eisenhower's orders made the critical difference. And incidentally, President Clinton hails from Arkansas. He was a white president from Arkansas. And 40 years later, he gave all these 9 children, whom we saw on the screen, a presidential gold medal. So therefore, this was a long way between what happened in the Cherokee case, where the president simply said that Chief Justice Marshall has made his decision, let him go and enforce it. And here was a president who sent the crack US Army to enforce a court decision. Now in December 2000, the US Supreme Court decided the election dispute between Bush and Gore. That was a dispute which was decided in about a week's time because the election couldn't be, the result was held up. This 5-4 decision, in fact, divided the nation. There were huge controversies about this decision. Everybody felt that it was Gore who had really won the election, but the composition of the Supreme Court was such that it favored Bush, President Bush, and Bush was declared as elected. It was a huge conflict. But the losing candidate Gore declared that he would abide by the Supreme Court decision, however wrong it appeared to him. He urged his followers and supporters to do the same and not even consider defying the Supreme Court decision. Friends, one last example, in 1941, Japan attacked Pearl Harbor, attacked America, and virtually destroyed the entire US fleet. Now you should watch those 2 movies. One is Tora 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 and Pearl Harbor, which portray this attack very dramatically. Now, nearly 2000 years ago, the great Cicero had declared that in times of war, the laws are silent. He said it in Latin, that what it means is that in times of war, the laws are silent. Now, President Roosevelt, following that principle, soon after the Pearl Harbor attack, rounded up all the US citizens, all means about a lakh of them, residing in the California region, of Japanese race, and incarcerated them in a military prison camp. Several camps were set up, and if anybody who was even an American citizen living for 3 generations or 4 generations in America, but if you were of a Japanese descent, then you were rounded up and put into the prison camps. They felt that this is not the time to take any chances. One Fred Korematsu challenged this before the US Supreme Court. And by a majority of 6-3, the US Supreme Court upheld the president's executive order. Even one of the most liberal judges, Judge Black, upheld this outrageous executive order, which had brazenly discriminated against the US citizens only based on race and ethnicity. In a closed door conference, it is written, before the judgment was delivered, Justice Black said that the nation has a war on its hands. The war must be run either by the president or the court. The court has no wherewithal to run the war, therefore, you should not interfere in the president's decision. So they went by Cicero that in times of war, the laws are silent. Now, the Korematsu decision is considered to be a blot on the judicial history in the United States. It is like the House of Lords decision in Liversidge versus Anderson, or like our decision in ADM Jabalpur's case. But in both these cases, there were heroic dissents. Our dissent was by Justice H.R. Khanna. Incidentally, our ADM Jabalpur has been overruled. In fact, Justice Chandrachud, Senior Justice Chandrachud, apologized after delivering the judgment in ADM Jabalpur extrajudicially. The judgment remained. And Justice D.Y. Chandrachud in Swami's case overruled the decision in ADM Jabalpur. Now, this was the decision in Korematsu, but let's come to 2001 when America suffered the 9/11 attacks, leaving almost 3,000 dead. Some of the worst terrorist attacks, in fact, in our lifetime also. America waged a war on terror and terrorist outfits like Al Qaeda. Several terrorists were killed, arrested. Now, America chose to detain some of the worst terrorists, including Osama bin Laden's personal bodyguard and driver, at Guantanamo Bay in Cuba. So, this place was in Cuba and it was leased out to America by the Cuban nation. So, it was not a place on the American soil. One of the reasons, avowed reasons for having a prison or for having this prison area outside the United States was so that the prisoners could not seek access to the US courts and complain about their detention or any human rights violations. Still, 4 petitions were filed before the US Supreme Court, and the argument was that the fact that the territory was outside, or I mean, the prison was outside the territorial jurisdiction of the US. It was admitted that this was a land leased out to America. It was admitted that this prison has been set up by America. It was admitted that it is the Americans who were holding them as prisoners. So the Supreme Court said that yes, our writ of habeas corpus will travel. The 4 petitions were allowed. Not that they were released, but the ruling of the Supreme Court was that they have a right to access to the US courts, the US federal courts, and the US federal courts will look into the issues of their detention and human rights violations. It is in this case that Korematsu was specifically overruled. They said that we are burying the ghost of Korematsu. And why I am including this is, if we can just see a small clip. President Bush was the president at this time, and it really stunned the president.
The U.S. government says they're enemies of the state, military prisoners at the U.S. base in Guantanamo, Cuba. Some have been held here for more than 6 years, suspected of involvement in acts of terror against the United States and legally outside the jurisdiction of U.S. courts. But Thursday's ruling throws a challenge to their continued incarceration. It gives detainees the right to ask for evidence, to call on witnesses, and even to ask a federal judge to set them free. Speaking to reporters at a news conference in Italy, President Bush reluctantly accepted the court's decision.
First of all, it's the Supreme Court decision. We'll abide by the court's decision. That doesn't mean I have to agree with it. It's a deeply divided court. And I strongly agree with those who dissented.
The dissenters, including Chief Justice John Roberts and Justice Antonin Scalia, criticized the ruling as judicial activism and warned the nation would live to regret it. But civil rights advocates called Thursday's ruling a major step forward. Michael Ratner is president of the Center for...
So, what did President Bush say? He says that it's the Supreme Court's decision, we will abide by it. But that doesn't necessarily mean that I have to agree with you. So, from the time of the Cherokee Nation cases till now, this has been the approach. And this is precisely what has been stated by Justice Stephen Breyer in his 3 beautifully written books about making democracy work, about the authority of the court and the peril of politics. And he has also discussed some of these cases. And he says that one of the strongest reasons for the longevity of the US Constitution is that now it has become a habit with the American people to accept the decisions of courts as binding on them, though they may disagree with them, though they may criticize them in the worst of terms, as long as the decision is not overturned by a judicial process or a permissible legislative process. Incidentally, he has recorded that there has been no constitutional amendment since 1861 for overruling a Supreme Court judgment. And what was that 1861 amendment? That was to overrule Dred Scott's case, where slavery was upheld by the Supreme Court, and the 13th Amendment said that slavery will be unconstitutional. But since 1861, there has not been a single amendment to the US Constitution to overrule a decision of a court. There have been other amendments. So therefore, Justice Breyer says that it is this habit which increases the longevity of a written constitution, and this is the habit which we must learn to develop. This is the habit that we must learn to inculcate. So on this eve of 75th day, 75th Constitution Day, I think we should give a thought to this habit and learn some lessons from whatever good. I'm not saying there is a lot of good in America, whatever good that is there in America, and also learn lessons from whatever bad things that have happened in that place. Now, I conclude by, I cannot resist quoting Judge Learned Hand and his famous quotation. In fact, he says that all these constitutions are all right, courts are all right, democracy is all right, but constitutionalism or liberty has to be in your heart. If it is in your heart, then it is indestructible. If it is not in your heart, then no amount of constitutions can really save you. And let me quote. He says, I often wonder whether we do not rest our hopes too much on constitutions, upon laws, and upon courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. But while it lies there, it needs no constitution, no law, or no court to save it. And what is this liberty which must lie in the hearts of men and women? It is not the ruthless, unbridled will. It is not the freedom to do as one likes. That is denial of liberty and leads straight to its overthrow. A society in which men recognize no check upon their freedom soon becomes a society where freedom is the possession of only a savage few, as we have learned to our sorrow. Friends, I must thank the High Court Bar Association and the Goa Legal Services Authority for this opportunity. I know I have transgressed my time. Please forgive me for it. I sincerely thank you for bearing up with me. Greetings for the Constitution Day and Jai Hind. Long live our Constitution.
Anybody having any questions?
So you could sit down.
Sometimes
I have a right to remain silent.
So sometimes the posers need something to break the ice and possibly warm them. So I'll let me just start with one question. So I will start with the first question. So by the time everybody just warms up and regroups after an enthralling speech like this. So the American Constitution, as you said, in democracy is a robust democracy. As much as you've said that it's courtesy the Supreme Court of the US and the fact that the citizens are now abiding by the decisions is a huge factor in the longevity. But would you also agree that the rigidity of the amendment process of the American Constitution does play a part in that, or is just the strength of the Constitution that has withstood for the last 236 years?
Really not given it a thought. They do have a fairly rigid process, but I tend to still believe that whatever the Constitution, what is more important is the people who run the Constitution. and it is the people who accept the constitution. That is what plays a major role. That is my honest opinion.
Thank you, sir. Your Lordship, it was a fascinating journey that you took us through for the last half an hour of the elaboration of the historical connect between these two, one the oldest and one the longest constitution. And being a student of constitutional law in United States, I can tell you, I was pondering upon my memory of 12 years back, my constitutional law classes, and especially the Guantanamo Bay case, the link. I have just one, kind of connected question. The constitutional history of India and America were slightly different, but we have both used a similar ideological reference of we the people. And this we the people have been, over the period of time in India, been a question of debate that were we correct or were we just borrowing. I do believe the constitutional framers had said that truly it is a representative evolution, and the Constituent Assembly was actually a representative evolution. So I'd like to know about maybe a reference from your side. My students are there, so they would also learn a lot from erudite ways of yours. Thank you very much.
I think the history was different, but it was also to a great extent similar. We had a common enemy, mind you, the British, both they as well as us. This is one aspect. Second aspect is, see, there is a criticism against our own Constituent Assembly. They said that it represented hardly 26 or 27% of the populace, because at that time, uh, even to be a voter, you had to have certain qualifications, educational qualifications, or you had to have some property,
You have to pay income tax.
or you have to pay income tax. That's right. So therefore, a lot of people were really excluded, and that is the reason they say that the provisions in our constitution for amendment were not made so rigid. The Constituent Assembly members, the statesmen that they were, realized that we are not really representing the entire India. There are so many who are unrepresented over here. So if we now voice our views on them or on future generations, that may not be very proper. Similarly, even in the US Constitution, though they talk of we the people, you will be surprised to know, I'm not very sure about the dates, but I think it is sometime in 1920s or so that they gave women the right to vote.
Late 30s.
Uh,
Late 30s.
1930s.
30s, late 30s.
Yeah, 1930s, yes. So it is, so therefore, we the people did not include women. We the people did not include the blacks, the slaves. These were the fault lines in the constitution. These were the similarities in our constitutional structure also. But by and large, I still feel that whatever a written document, ultimately democracy thrives on the principle that it is the people who are sovereign, and that is why we use the word we the people. It is the sovereignty rests in the people, and since this is a people's document, this will be paramount, this will be supreme. Even in our, even in Marbury versus Madison, the argument was that if the sovereignty is with the people and the people have made this document, then this document becomes paramount. It is under this document that a Congress has been created or the legislature has been created. So the Congress or the legislature is only a delegate of the people. Now a law made by the delegate and law made by the sovereign, which one will prevail? That was the argument, and that is why judicial review. Thank you.
Thank you, Honorable Justice Sona. Over the years, uh, over the years, you enthralled us with your erudition, your articulation, and eloquence, and high standard of presentation. And as if that was not enough, you've added a flavor of audio visual to make it even more of an immersive experience for us. But I will just, I know it's taken some time, but I will just add two bits of mine. So the average uh, longevity for world constitution is about 70 years. That is the, so we've crossed that. And just to end on a lighter note, on the topic today, the constitution of France has changed. They've had multiple constitutions. The joke going round is that somebody goes to a bookstore in France and says, "Can I have a book, the French Constitution?" So the book vendor says, "We don't sell periodicals." So thank you, Honorable Mrs. Sona, once again. It is indeed a matter of immense pride for the Goa State Legal Service Authority and the Goa High Court Bar Association that a person of your stature and caliber has graced this occasion and made it a memorable National Law Day event. Uh, may I just request our President, Senior Advocate Coelho Pereira, to hand over a token of appreciation to Honorable Justice Sona. Knowing that you are a Mauritius reader, I'm sure it will be a prized possession in your library. Thank you once and all. But may I just request the Member Secretary of Goa State Legal Services Authority to deliver the vote of thanks for today's function.
Respected dignitaries, senior advocates, and all present here, it's my privilege to propose a vote of thanks and acknowledge the contribution of all those who worked really hard to make this program a great success. Firstly, I take the privilege to thank today's key speaker, Justice Mahesh Sonar, Honorable Judge of High Court of Bombay and Executive Chairperson of Goa State Legal Service Authority, who had traveled all the way from Mumbai to Goa to enlighten us on the topic of Constitution in spite of his busy schedule. Topic covered today by Lordship will help us in all our professional work, and it will especially help the law students who are present here as they have this subject of Constitution of India in their syllabus. Thank you, Lordship, for the informative talk. In spite of busy schedule, the Honorable High Court judges present here today also contributed by their presence. I take this opportunity to thank Honorable Justice P. Deshpande, High Court Judge, High Court of Bombay at Goa, and Chairperson of Goa State Legal Service Authority, Honorable Justice Madam Nivedita Prakash Mehta, Judge, High Court of Bombay at Goa. I thank you all once again. I also thank Learned Advocate General for the State of Goa, Devidas Pangam, for his presence. Thank you, sir. I thank Principal District and Session Judge Sri Isha Daga for attending today's function. Thank you, sir. I also thank President of Goa High Court Bar Association, Senior Advocate Mr. Coelho Pereira, and all the members of the committee for their contribution for today's event. I thank senior advocate present today and all other advocates and my colleagues present today. I thank all the law students and convey my thanks to the principal of law colleges for sending you all for today's program. I thank all the staff of Goa State Legal Service Authority for putting up hard work for preparation and for making this program happen and make it success. I also thank all the reporters, Doordarshan, RDX and other reporters for covering today's event. Thank you so much. I thank all present here today. I thank each and every individual personally for making this event successful. Pardon me if I have missed anyone. Please accept my thanks if I missed anyone. Thank you. I request everyone to stand up for our national anthem.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाये तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे